Okay, thank you all so much for being here. I am going to introduce you to your panelists for today as we talk about employment agreements and whether your company is protected. So first we'll be hearing from Adam Wright. Adam is the Vice President of Legal Product here at 650. He's a graduate of the University of Michigan Law School. We have a couple of those over here and they always get really excited when it's Go Blue weekend. So prior to joining us, Adam he clerked as a federal judicial law clerk and then worked in private practice where he focused on intellectual property, employment, and commercial litigation. And also with us today is Josh Baca. Josh is a recent graduate of the University of New Mexico Law School. And prior to coming over to work with us as a legal product associate, he worked in employment law in New Mexico. And he also, this is a fun fact I happen to know about Josh, he hiked from Mexico to, oh, you're gonna have to chime in, Josh. Was it all the way to Canada or did you stop in Washington?
It was Canada.
Canada. So he definitely spent his time in between law school and the bar better than I did. So we're very excited to have Josh and Adam both with us today. And with that, I know we want to get quickly to the content. So, oh, I should introduce myself. My name is Marie. I'm the general counsel here at 650 and have been running operations in terms of implementing our own COVID policies and also implementing employment agreements and sending those out and working with, sending employees in new states and hiring employees in new states. So I have sort of the on the ground experience for the topics we'll be talking about today. So with that, Adam, I'll turn it over.
Going to turn it over
Josh
to
is going first.
Josh is going to start us off today.
I do apologize. Thank you, Josh.
Yeah, so first we've got an agenda up here. And so we're going to be speaking about whether our non-competes and non-solicitation agreements are enforceable, what kind of limits there are on non-disclosure and confidentiality agreements, what kind of bans are enforceable in arbitration, and what states govern a remote workforce. I'll be talking about the first, whether non-competes and non-solicitation agreements are enforceable. Adam is going to be talking a little bit more about non-disclosure and confidentiality agreements and arbitration, and Marie is going to be talking a little later on what states govern remote workforces. So if we go to the next slide. So I'm going to be talking about non-competes and non-solicitations, and for people who may not be using them currently or are not sure of the distinction, I figured I'd put that up here. Non-compete agreements are those where it's a contract where an employee agrees not to compete with a company for a certain period of time after employment, meaning they're just agreed to not engage in the same type of business practices that they had otherwise been performing. Non-solicitation agreements are a little different. They're a contract where an employee agrees not to solicit the company's clients, employees, or other individuals they might have worked with during their employ. So they agree not to steal people from their previous employer. Now, as we go forward, let's keep in mind that when I'm talking about non-compete agreements and non-solicitations, this is in the context of employment agreements. There might be differences when it comes to non-competes included as part of maybe severance agreements, but that's not what we're talking about right here. This is really just the initial employment. So if we hop to the next slide. Before we get into the real updates of what states have been doing, I thought I'd point out that there are some current states that have limitations already in place, and some of what those limitations are, just so that you get a feel for what might be something to look into. I'm going to skip over a couple of these because they are updated later. So for instance, Colorado and Illinois have some changes that we'll talk about later. But if we look at Maine, let's go back to there. Yeah, let's just stay here for a while. In Maine, one of the restrictions is that there's an income threshold, and you'll see different income thresholds across the variety of states that have these kind of restrictions. But for instance, in Maine, it's 400% of the federal poverty level, meaning non-compete agreements cannot be enforced against a person who makes less than 400% of the federal poverty level. And that level goes up and down. It changes every year. And I don't have the numbers off the top of my head, but that's one thing to just kind of keep in your mind as you're drafting these kind of documents. Maryland has a similar threshold, but theirs is dictated at $15 an hour or $31,200 annually. So similar kind of income threshold, just measured a little differently. Massachusetts is one state that is particularly cumbersome for employers, not only because they have an income threshold, but they have a requirement called garden leave. So garden leave is a term used to describe when an employee is leaving a job. They're required to stay away from work for a period of time while they're continuing to be paid. So basically, employers are paying the employee to just not work in that field. And so in Massachusetts, garden leave is required to be no less than 50% of their annual base salary. So with a maximum of 1 year term, that means employers can pay up to a year of 50% base salary for an employee to, not engage in whatever kind of business practices they're agreeing to. Now that's one of the big kinds of consideration that are given for enforcement of a non-compete agreement. Consideration being, basically what you pay to have somebody agree to that agreement. Now, if we look at New Hampshire also has an income threshold, but that one is at 200% of the poverty level, the federal poverty level, excuse me. Nevada, they don't really have an income threshold per se, but they are non-compete agreements are not enforceable against hourly employees. So this just kind of goes to show that there are a variety of states and that have restrictions against what kinds of non-compete agreements are enforceable and what needs to be done to actually enforce them. So those are just a few states that you need to keep your eyes on. Now, if we go to the next slide, there are a few jurisdictions that have total bans against non-competes. And those 4 are listed here. So there's California, Washington, DC, Oklahoma, and North Dakota. Now, so California and North Dakota are just complete bans for both non-competes and non-solicitation agreements. They're just outright non-enforceable. Oklahoma permits some non-solicitation agreements to the extent that they're prohibited from soliciting customers. So non-solicitation agreements wherein an employee agrees to not solicit other employees, those are not permissive, but non-solicitations where they're prohibited from, going after customers, those ones are permitted. Now, DC is a little bit strange. DC's ban has been approved and it technically has the force of law currently. However, due to budgetary issues, it won't be enforced until April 1st when they have the chance to balance the budget and push that through. So that one is in place, just not enforced at the moment. And DC has some large changes that you might want to keep your eyes on. For instance, so this is just basically a complete ban on non-compete agreements. And employers can face some penalties, up to, I think it was $10,000 for repeat violations. Now, this is not retroactive. So employers who have non-compete agreements already in place can still enforce those agreements. This is really just proactive in that you cannot proliferate any more of them. One thing to note about DC's ban is that it requires notice to be provided to all employees, current and future employees. There's a written notice that must be given to them, and it's very specific. It says that so in quotes, no employer operating in the District of Columbia may request or require any employee working in the District of Columbia to agree to a non-compete policy or agreement in accordance with the ban of non-compete agreements amendment of 2020. So that phrase must be included in any employment agreement going forward. So that's another one of these changes that we see frequently coming up and restrictions that you need to keep your eyes on. Regarding continuing updates, if we go to the next slide, we'll see a few more states that have made some changes as of this year. Colorado, beginning on March 1st, Colorado will begin criminalizing certain restrictive covenants, like non-compete agreements and non-solicitation agreements. And any employer who violates the statute is guilty of a Class 2 misdemeanor, which is punishable by 120 days imprisonment, $750 fine, or both. So actual criminal penalties for violations of this non-compete statute. Illinois has enacted recent amendments to its Freedom to Work Act, and those went into effect the 1st of this year. Now, this law imposes an income threshold for enforcement for both non-competes and non-solicitation agreements. For for non-compete agreements, employees must make more than $75,000 per year. For non-solicitation agreements, they have to make more than $45,000 per year. One thing you'll note about Illinois' new statute is that it is very detailed. They go into depth on what they require and what they prohibit for both non-solicitation agreements and non-compete agreements. And so a couple of these things, like you see here, is that income threshold of $75,000 and $45,000 for non-competes and non-solicitations. Another thing that Illinois has enacted is there are new consideration requirements. As I mentioned before, consideration is basically what you pay to have an employee agree to a non-solicitation or non-compete. And so there are vagaries that I won't go into in the statute, but they have very specific rules that you need to follow. There's also notice requirements included in Illinois' update. Employers are now, they must also give employees 14 days to consider the restrictive covenant and to advise the employees to consult an attorney before accepting one. And this one also has fines. Now, this isn't criminalized, so you can't have jail time, but there can be violations. There can be fines for violations of $5,000 for initial violations and $10,000 for repeats. Some other updates that we see here, Oregon recently updated their income threshold to people who earn more than $100,533 per year. Similarly, Washington updated their earnings threshold to $107,301.04. These are very specific numbers, as you can see, and both of these are measured based on the cost of living growth calculated federally per year. So I think it's in September, each of these numbers is calculated and it's put into place on January 1st every year. So you'll see Oregon and Washington both kind of doing a little step up each year. Now, New York hasn't actively put into place any restrictions or limitations on non-competes, but as part of her comprehensive plan to strengthen New York's workforce and help grow the economy, Governor Hochul announced that she intends to introduce legislation that would ban non-compete agreements. The actual legislation has not yet been submitted. She also pledged to ban all no-poach agreements, which makes it seem like she intends to also do away with non-solicitations. As you recall, no-poach might mean non-solicitation from, you wouldn't be able to steal clients or previous employees. Now, at the federal level, we also see some different action. There are essentially 3 different steps being taken. There has been no actual decisions made yet. However, President Biden issued his executive order on promoting competition in the American economy on July 9th, 2021. He requested that the FTC implement statutes curtailing the use of non-compete and other restrictive covenants that unfairly limit worker mobility. Now, the FTC has not made any filings, but it has begun taking steps like fact-finding. They've held workshops and in order to prepare and kind of get their minds around what needs to be included in these statutes. Congress, independently and at the same time, has pushed the Freedom to Compete Act for review in the Senate. That happened on July 15th of last year. Now, this act is very far-reaching and it would void all existing non-competes and prohibit them going forward. So as we looked at previously, the DC law voids all forward-looking movement in non-competes. This would look backwards as well and void anything in existence. So as you can see, this would be a huge, huge far-reaching act, but we expect that it's going to have amendments made, and we'll see some opposition to it, but that's another one to keep your eye on. And finally, at the federal level, we've got the Workforce Mobility Act, which was introduced in Congress on February 25th last year. Now, and this bill would prohibit the enforcement of any new non-compete agreements similar to DC, except regarding the sale of a business. And that's not really what we're talking about, so it's not really relevant, but that's one of the distinctions we'll see in these cases. Now, before I turn it over to Adam, I just want to make a note that there are some businesses that may use non-compete agreements as like a matter of course, or possibly as a way to frighten employees from moving into a different area of work, just to prohibit them from competing. But these kind of new laws are making that practice dubious. There are fines, and as we see in Colorado, even criminal jail time associated with misuse of non-compete agreements. That coupled with the fact that many states are even requiring specific notice of these illegal practices is something that might serve to motivate a re-examination of your current non-compete and non-solicitation agreements. So with that, I'll turn the time over to Adam.
Thanks, Josh. So as you can tell from Josh's presentation, the law surrounding restrictive covenants is moving very quickly. I think last year, something like 26 states introduced legislation to limit non-disclosure, to limit use of non-competes. Another area of the law that is changing very quickly is non-disclosure and confidentiality agreements. Just a quick note, I will be using those terms interchangeably today. So I'll be, if I say NDAs, what I'm talking about applies equally to confidentiality agreements. And what we're talking about today would also generally apply to non-disparagement agreements as well. So generally, what is an NDA? Why do employers like them? What do they use them for? Well, they're used for several different reasons. One reason is to protect company trade secrets and proprietary information, but there's another use for them as well. And some companies use them to prohibit employees from disclosing unlawful employment practices in the workplace that they have either observed or been a victim of. There are two categories of employee NDAs. There are pre-dispute NDAs, and those are NDAs that are used in employment contracts, for example, or in standalone NDA agreements that an employee may sign at the beginning of employment. And then there are post-dispute NDAs, which are NDAs that would be contained in a settlement agreement, for example, after an employee has filed a claim against the employer. NDAs that prohibit disclosure of facts related to claims of sexual harassment and discrimination in the workplace have been coming under increasing fire in recent years. So they're, and because of that, states have started implementing and passing laws that limit the use of NDAs in this context. And we're going to talk about those in more detail in just a minute. But the state laws that are limiting the use of NDAs have their origins in the Me Too movement. The employer's use of NDAs to silence victims of sexual harassment has been prominent, obviously, in the news in recent years. And in 2018, several states started taking action to address that problem. All right, let's go to the next slide. So what do these laws do? I think first it's helpful to talk about what the laws don't do. So, when employers hear that states are banning NDAs or confidentiality agreements or limiting them, I'm sure a lot of alarm bells start to go off because those are really important to protect, company confidential information like trade secrets or other proprietary information. But the state laws that we're talking about today, they don't place an outright ban on NDAs in all contexts. So companies can still use NDAs and confidentiality agreements to protect their trade secrets or IP or other proprietary information. And we already had a question about this in the chat regarding the use of non-disclosure agreements related to proprietary invention and assignment agreements. So really, you can rest easy in knowing that these laws aren't going to affect a company's ability to protect its trade secrets. So the laws we're talking about they're really targeting employers' use of NDAs to silence victims of harassment and discrimination. States limiting NDAs have taken two broad approaches. First, some states limit non-disclosure agreements with respect only to sexual harassment or abuse claims. Second, other states go a little bit further and ban them with respect to all discrimination claims. So that would be discrimination based on any protected class. So like race, sex, religion, national origin, for example. These laws that we'll talk about often contain exceptions. Some common exceptions that we see are permitting NDAs at the request of the claimant. So you might imagine a claimant may want to keep their own identity confidential. If that's the case, the laws do allow for an NDA to keep that information confidential. And some of them also allow the settlement amount to remain confidential as well. So these laws are limited to the disclosure of facts related to discrimination claims, but they are notable because companies are used to operating in a legal landscape where, for example, a benefit of settling a sexual harassment claim is knowing that the details of that claim won't become public. But obviously the tendency of those provisions to perpetuate sexual harassment in the workplace has been problematic, which is why states have taken action to limit their use in these circumstances. So states with limits are California, Illinois, Maryland, Nevada, New Jersey, New Mexico, New York, Oregon, Tennessee, Vermont, Virginia, and Washington. And we'll talk specifically about what some of these states are doing. One quick side note that companies should be aware of is that NDAs in sexual harassment settlements do raise federal tax issues. So even if an NDA in a sexual harassment settlement agreement is allowed under your state law, the company can't claim that settlement payment as a federal tax deduction if there's an NDA in a settlement agreement under federal law. So just a note that you should be aware of. All right, let's go to the next slide. And yeah.
Oh, sorry, I was just going to chime in really quick since you were giving some advice that, or some information that might be considered more on the side of, the practical perspective. I would just add that from the perspective of, recruiting and diversity, equity, and inclusion, as you're trying to make strides forward for your company in those spaces, that, even if you're in a state that would allow the NDA, you still should, I would recommend from the perspective of being general counsel for my company, consider putting in the language that would limit it in those sexual harassment and discrimination situations, because it's a good practice to show that your company is attempting to be a good actor in those spaces.
Yeah, that's a great point, Marie. Thanks for adding that. So some of the states that are limiting NDAs, here's what they're doing, and we're not going to have the time to dive into every state that's limiting NDAs, but I think these states will give you a good sense of the different approaches that states are taking. So as you can tell from the list of states on the last slide, most states don't have laws limiting the use of NDAs, but as Marie said, it's probably a best practice to include similar language. But even in those states that don't specifically limit NDAs, this is an area of the law that is changing very quickly. So I wouldn't be surprised to see more states taking action in that area in the future. So keep your eye on laws in the states where you operate for any laws coming down the pike that may be limiting the use of NDAs. All right, so first we'll talk about everyone's favorite employment law state, California. So we'll talk about these laws in terms of what they limit in the pre-dispute context, so in employment agreements, and the post-dispute context, so settlement agreements. In California, in a pre-dispute agreement, so an employment contract, you can't deny the right to disclose information about unlawful acts in the workplace. A pre-dispute NDA in California does require very specific language stating that nothing in the agreement prevents the employee from disclosing unlawful acts in the workplace. So you need to make sure you're including that very specific language in your employment agreements if you have an NDA. For post-dispute agreements, so for settlement agreements in California, you can't prevent the disclosure of facts about any discrimination, harassment, or retaliation claim, or any information about unlawful acts in the workplace. And this is a recent change in California law. Initially, the limit was just to sexual harassment claims, but starting January 1st of this year, that now includes any discrimination claim. There are some exceptions under the law, so you can have an NDA like we talked about to protect the claimant's identity upon the claimant's request. You can have a NDA to cover the settlement amount. And then potentially a big exception would be for negotiated settlement agreements. So a negotiated settlement agreement is one that is voluntary. It provides consideration, which is just some sort of type of legal benefit to the employee. And then it requires that the employee either be represented by counsel or be notified that they have a right to retain counsel. So again, if it's truly negotiated bilateral agreement and it isn't a take it or leave it agreement, then the law does permit an NDA to be included. Okay, moving on to Illinois. Similarly, in a pre-dispute agreement, you can't prevent employees or applicants from making truthful disclosures about unlawful employment practices. In settlement agreements, you can't require confidentiality about any type of discrimination, harassment, or retaliation. Illinois, sort of similar to that negotiated settlement agreement exception we saw in California, there are exceptions for mutual agreements, but the statute sets out really strict requirements about what has to be included to demonstrate that the agreement is actually mutual. And there are too many specific requirements to go into detail here in that statute. But just an example, if you're including an NDA in a settlement agreement, in Illinois settlement of any discrimination claim, you're going to have to give the employee a 21-day review period and then a 7-day revocation period. So after they sign the agreement, they still have 7 days to revoke it. And that's just one of the many requirements that Illinois has to meet their exception to the ban or limitation on NDAs. In Nevada, for both pre and post dispute NDAs, you can't prohibit testimony about any criminal offense, sexual harassment, or discrimination. That's based on any protected category. Now, really, an employer in any state should have this language. So you shouldn't be prohibiting this conduct in any state, because that would raise some problems potentially with the EEOC. But the Nevada statute makes that explicit. It also has an additional limitation for NDAs and settlement agreements. You can't prohibit disclosure of facts related to a sexual offense or sex discrimination. And then again, there's an exception for the claimant's identity. New Jersey, for both pre and post dispute NDAs, you can't prohibit disclosure about any claim of discrimination or retaliation. And NDAs are only enforceable against employers, but there's an exception here. So typically, if the claimant wants to include an NDA in New Jersey, you can do it. And it's only enforceable against the employer. So you can't an employer couldn't enforce an NDA against an employee. There's an exception, which is that if the employee publicly reveals details that lead to the identification of the employer, then the employee can no longer enforce that against that NDA against the employer. New Jersey has explicit exceptions for non-competes, proprietary information, and trade secrets. So again, the law just makes it explicit that you can have confidentiality provisions to protect your IP and trade secrets. All right, let's go on to the next slide. A few other states here. New York, in employment agreements, you can't prohibit the disclosure of future discrimination claims unless you include a specific carve-out and specifically state that the NDA doesn't prohibit the employee from cooperating with government agencies in filing discrimination claims in the investigation or any proceeding related to a discrimination claim. So as long as you include that carve out, you can include an NDA in your employment contract in New York. For post disputes of settlement agreements in New York, NDAs are prohibited in all discrimination, harassment, and retaliation settlements. Again, there is an exception for the claimant's identity upon the claimant's request, but New York is sort of unique here. So if the claimant does request an NDA, then the employer has to follow a very specific process set out under New York law. So you essentially have to have two agreements. One, you have to have an agreement that specifically explicitly states that it's the claimant's preference to have an NDA. And then you have to give the claimant 21 days to review the terms of the NDA, and then 7 days to revoke the NDA as well. Tennessee and Virginia both take similar approaches. So for pre-dispute employment contracts, you can't prohibit disclosure about facts related to sexual assault claims. So these are more limited. They don't apply to all discrimination claims, just sexual harassment. And then neither state has any post-dispute limitation. In Vermont, you can't prohibit an employee from opposing, disclosing, reporting, or participating in an investigation of sexual harassment in an employment contract. And then Vermont is similarly limited to sexual harassment claims. So in a settlement agreement, you can't prohibit a complaint to a state agency, or again, participation in an investigation or discovery. And then it also has a ban on no rehire agreements. So often, well, sometimes companies will include no rehire agreements, which say that after we settle this claim, the claimant can't work here anymore, essentially. And so the Vermont statute prohibits that. All right, so what are the best practices for employers going forward, given these limitations on NDAs? Well, it's a rapidly evolving area of the law, as we can see, and it's important that companies are really staying up to date and in compliance with their NDAs, making sure that they aren't including language in their NDAs that would be prohibited under any of these state laws. And then even if you don't have employees in one of these states, you should probably review your NDA just to make sure that it couldn't be interpreted as prohibiting an employee from filing an employment claim with the EEOC or equivalent state agency, or testifying or participating in an investigation of an employment claim. The task of keeping your NDAs up to date is especially hard for companies with remote workforces spread among several states. And Marie will talk in a minute about which states' laws those companies really need to be monitoring to make sure they're up to date. All right, so let's move on now to talk about limitations states are placing on employers' ability to arbitrate employment claims. This is also an area of the law that's changing very quickly. As you probably know, arbitration refers to a private dispute resolution forum. So in the employment context, in an arbitration agreement, the employer and the employee both give up their right to file a lawsuit in court to resolve an employment dispute. And then instead they are agreeing to resolve the dispute in front of an arbitrator or a panel of arbitrators. Unlike lawsuits filed in court, arbitration is not a public process. So any documents you're filing in connection with the arbitration aren't going to be publicly available. Employers often prefer arbitration for several reasons. One, it's often quicker than litigation, so you'll get a resolution quicker. It's often cheaper than litigation. And then again, it's non-public. But one note on non-public, non-public doesn't mean confidential necessarily. So even though it's non-public, that doesn't necessarily prohibit the employee from disclosing any of the facts or circumstances related to the claim that's being arbitrated. To do that, you would need a confidentiality agreement. But then again, that goes back to what we were just talking about. There are practical considerations like Marie brought up, and then also legal restrictions on use of confidentiality agreements, as we've seen. Anytime you're talking about arbitration, you need to talk about the Federal Arbitration Act, or the FAA. It's a very broad federal law that's very friendly toward arbitration. With few exceptions, the FAA can govern almost all employee arbitration agreements, and employers typically prefer to have the FAA apply instead of varying state arbitration laws. Where an arbitration agreement specifies that the FAA governs, the FAA will typically preempt any state arbitration law, and the Supreme Court has ruled that many times. But states are now attempting to ban mandatory arbitration in employment disputes and are taking various approaches to try to get around that federal preemption to varying degrees of success. And so let's take a look at some of those states quickly to see what they're doing. So there are two main approaches that states are taking, similar to what we saw in the NDA context. There are states that are banning arbitration of all employment discrimination cases, and then states that are banning just arbitration of just sexual harassment claims. And then a lot of these laws, like the NDA limitations, came as a result of the Me Too movement. So we're going to talk specifically about California, Illinois, New York, and Washington, but there are a few other states that have limits that you should be aware of too, and that's Maryland, which applies only to the arbitration of sexual harassment claims. New Jersey applies to all discrimination claims, and then Vermont, which applies only to sexual harassment claims. There is also some movement at the federal level to limit the use of mandatory arbitration in the employment context, but those efforts haven't gained much traction so far. All right, back to California. So California prohibits employers from, as a condition of employment, requiring employees to arbitrate a violation of the California Fair Employment and Housing Act or Labor Code, and that's essentially covers all employment-related claims. That phrase, as a condition of employment, turns out to be quite important. So courts have read that to mean that unilateral arbitration agreements are not permitted. Again, agreements that are sort of take it or leave it, but that mutual negotiated arbitration agreements are permissible under the law. There are exceptions for settlement agreements and negotiated severance agreements. So in those agreements in California, you can include an arbitration provision. And the status of this law is in limbo right now. So traditionally and historically, I guess, laws that state laws that are attempting to limit arbitration have been found to be preempted by the FAA and therefore not enforceable. And that is what an initially a lower court found actually with respect to the California law. It found that the FAA preempted the California law and could not be, so the California law was not enforceable. However, a panel of 3 judges on the Ninth Circuit concluded otherwise and found that the law was permissible because it didn't ban all arbitration agreements, it just banned unilateral non-negotiated arbitration agreements. So negotiated agreements were still permissible, and therefore it found the FAA didn't preempt the California law. That is the current status of the California law, so it's currently in effect. But the Chamber of Commerce, which is a party to that litigation, has requested that the entire Ninth Circuit review the 3-judge panel's decision. So it remains to be seen what's going to happen with that law. This is definitely a case that could end up at the Supreme Court. The Supreme Court has not been shy to take arbitration cases in the past. So, but currently this law is in effect. So if you're operating in California, you need to be careful with your arbitration agreements. Similarly, in Illinois, employers can't require as a unilateral condition of employment an employee to arbitrate harassment or discrimination claims. There are, again, exceptions for mutual agreements that have been negotiated, and like with NDAs, the Illinois law sets out very specific requirements about what you must include in the agreement to show that it was mutual. This law is very new. It has not, it is in effect, but it hasn't been challenged yet, although we expect to see some challenges. Again, that law isn't in effect right now. New York, initially, New York only prohibited arbitration of sexual harassment claims. They have recently amended that law to expand it to ban arbitration of all discrimination claims. Again, there's an exception for a mutual arbitration agreement like we've talked about. The legal status of this one is interesting. There is a split of authority, but it's weighs heavily in favor of federal preemption. So 3 federal courts and 2 New York state courts have found that the FAA preempts the New York law, meaning that employees can be required to arbitrate discrimination claims. But there is one New York state court that has found the opposite and found that the New York state law was not preempted. So again, the issue hasn't been resolved in New York. So if you're operating in New York, you need to be careful about the language of your arbitration agreements. Washington, under Washington law, you can't require arbitration of any discrimination claim. There's no statutory exceptions in Washington. Like the Illinois law, this law is currently in effect and has been unchallenged. So again, it remains to be seen whether the FAA preempts the Washington state law. So before we move on, let's just talk briefly about best practices. So what are employers supposed to do now with these state bans on mandatory arbitration, which may or may not be preempted by the FAA? Again, this situation is really difficult for employers with remote workforces where you have to potentially be complying with the laws of many states. But employers need to be mindful that requiring employees in these states to sign arbitration agreements to settle discrimination or harassment claims could, potentially result in litigation. So again, if you have employees in these states, you need to think closely about the language in your arbitration agreements. So what we have seen many companies doing to address this this issue is explicitly state in your arbitration agreement that the FAA governs the arbitration agreement. And that's most employers include that as a matter of course anyway. But if you have an employee in one of these states that limit arbitration, then you can say that to the extent the state law remains in effect and is not preempted by the FAA, the arbitration agreement doesn't govern the claims that are, for which arbitration is prohibited under state law. So it sort of keeps you in compliance with the state law to the extent that it is in effect and not preempted by the FAA, but provides that the FAA is going to govern to the extent it's the state law is preempted. So that's one approach we've seen companies taking. Like with NDAs, you want to make sure to include language in your arbitration provision that the agreement doesn't prohibit filing a discrimination charge with the government agency or participating in an investigation of workplace wrongdoing.
Okay, so now we're going to spend a few minutes talking about governing law. Adam and Josh have done a great job taking you through some of the differences that we see across the states when it comes to your non-compete and non-solicitation agreements, your arbitration agreements. And of course, the question then becomes, well, when do those laws apply to me and to certain of my employees? Because your employees may not all be in the same state that you're headquartered in. They may have moved during the pandemic. There's a lot of moving parts when it comes to the governing law question. And so just, in addition to the examples that we talked about today, I do just want to call out the fact that governing law also has impacts in other areas outside of the types of agreements we've been discussing. Adam actually did tee up taxes for a moment, sales tax, corporate income tax, franchise tax, use tax, and those all matter. Where do you have employees? It can impact your taxation questions. Leave requirements can be very different across different states, and even within states, you have some jurisdictions, particularly larger metropolitan areas, that may have additional requirements. And of course, insurance requirements, payment into and participation in the state unemployment insurance fund can be dependent upon what's the governing law, where are these employees considered to be employed. So there's quite a bit going on here. And I just wanted to sort of call that out because as we talk today, the answer sometimes in the governing law question is it's not clear. And it may not be clear because it's different in these different types of scenarios. So keeping that in mind, I will give you the simple answer. If you want to advance to the next slide, the simple answer to governing law is that typically the law that applies will most likely be the law of the jurisdiction where your employee is working. So if I have a company that is headquartered in California, I have a remote employee who only works in the state of Massachusetts, Massachusetts is going to be the governing law when I'm talking about non-solicitation agreements with that employee, non-compete agreements, arbitration agreements. So that is the basic answer. Of course, we're talking about it in a CLE because there's some variations of that make it a little trickier sometimes. So if we want to go one more slide down, you want to think about the situations where there may be more than one state that you're dealing with. Typically, if you have an employee who's only working in the place where you have an office, that's very easy. They're coming into the office, it's that state where the office is located. Even if maybe the office is in New York and the employee lives in New Jersey, if they're always coming into New York law applies. So where they are in person, it's a single location, it's very easy. The hybrid situation can be a little bit tricky because of the pandemic. So say a person is coming into the office some days, but staying home other days. Typically, you would have to say, well, are they in the same state on all of those days? Because if they're not, then we need to look at multiple jurisdictions. But I actually put hybrid up here on the single one because there are some states that have passed special pandemic exemptions where essentially, if you have an employee who's working from home only because of the pandemic, who would typically be in office, there may be an exemption that says, even if they're working from home in this other state, we've passed a temporary rule that says we're still going to treat them as an employee only in the state where their typical location is. Now, a lot of those rules are phasing out. So if you are in a place that has had one of those exemptions, it's highly likely that if it has not already phased out, it might be about to phase out. So that would push you down into the second row of the slide, which would be there might be multiple states you have to look at to reach a determination. And then of course, your fully remote employee. So no matter where your office is, they're always working from home and only from one state. That's easy. But what if they're working remotely and they spend half of the year at their house in the mountains and the other half of the year at their house on the beach because you pay them very well? Well, in that situation, you have some competing jurisdictions and governing law questions that you'll have to look into more closely. But I'll also, again, give you the basic general rule that will help you, which is in those situations where there could be more than one state where both states could assert that they are the right state for the governing law, and try to make your agreements always consistent with the more strict state. So the one that is more generous to the employee and less generous to you, because then if there is an issue and you end up having to go to litigation in the state that you would not prefer, you're not going to have your agreements thrown out because they're violative of the rules in the more strict state. So that's a good general rule of thumb. But again, it doesn't quite get you there. And we want to talk you through some of the ins and outs of what this might actually look like for you. So keeping kind of all of this in mind, you can try to specify a governing law in your contract if there's going to be, you should always specify governing law in your contract, I should say it that way. But you should also think about whether that choice will be recognized by a court. And so to help you do that, we kind of have gone through some of the different variations of what you need to think through. And so the different factors, whether the employee is only performing services in one state. If they are, again, that is always the easiest situation. If they're performing services in multiple states, think about whether, in some of those states, the services are only incidental. So for example, you have an employee who's based in Indiana. About twice a year, they go to the state of California to attend a conference. It's a required part of their job. They have to go to that conference, but it's incidental. It's, it's not routine. It's short periods of time, and it's just this attendance at this one thing. Again, your choice of law should allow you to choose the state from which they are performing their substantive work. But what if you're performing some substantial services in different states where none of them is really the primary state? So in this situation, you might think of a larger company that has a number of workers that they send out to work sites across the country, maybe even in different countries sometimes, where you send them on a job, they go perform that job. It might last a few months, and when that job ends, you're sending them to yet another state to go perform at a second work site. And so it's not really clear, based on where the employee is working, what governing law might apply. In that situation, you might then ask yourself, well, where's the base of operations for the business? So, I have an employee who spent 2 months in California and 2 months in Nevada, and 6 months at a site in Florida, and then sort of hopped around 3 different sites at the end of the year. And we've always been sending them instructions from Texas. Can we say Texas? I'll give you sort of the hack to that one. They never worked in Texas, so don't try Texas. But it can get really tricky when you start having your employees move around more, where there's more states that have a stronger nexus with that employee than just the typical, the employee is always in this place, maybe incidentally visiting other places. So selecting choice of law there can become a little bit trickier. And when it comes to your contracts, I would say there are some tests that you can implement to sort of kind of get an idea for what law might govern, so that you can pick the right one in your contract. But keeping in mind that some of these tests are not specifically geared towards the situation of what law governs in the non-disclosure agreement, what law governs in your arbitration agreement. Some of the best cases we have are really focused on other areas like tax. And so we can sort of use the same factors to try and come out to a determination of which law might apply, but you still may have some tricky situations where you'll want to consult with counsel, or you'll want to explicitly state in your contracts situations in which other multiple state laws might apply. And I'll talk about that in a minute, why you might want to do that. It's very rare though. So if we could go to the next slide here, I'm going to give you some examples. So we do have what's called the localization test that the Department of Labor uses. The Department of Labor uses that to determine which state you should report an employee's taxes in. So their income is taxable in which state. And I say again, like, this is specific to where are they taxable. It doesn't mean it's the only employment law that applies to that employee, okay? But it might be helpful in helping you decide what governing law you should select in an attempt to control that decision if there is litigation later. And so when we talk about the Department of Labor test, you should think through essentially 4 different fairly important questions. And essentially their localization of the employee's work, base of operations for the employee, not for the company this time, the place of direction and controls, that typically would be the company's base of operations. And if none of those apply, where does the employee reside? So those are sort of the things that come in the DOL test for determining where an employee's income is taxed. But we can see as we talk through some of the examples of that test being used, we can see how it could come across into other areas of employment law to determine what the governing law is. Because at the end of the day, it's usually about nexus, where the strongest relationship is, and that could change at different times. So the example that I was looking at was a New Jersey airline. So you have an airline that's based in New Jersey. It's acquired by another company, and you had a set of employees, flight attendants, pilots who'd been based in New Jersey, who now have a new hub, and their new hub is in Missouri. So every day they leave their homes in New Jersey, they go to the hub in Missouri, and from there they fly to various other states and potentially even countries as part of their job. At the end of their shift, they are back at the Missouri airport where they started, and they drive back home to New Jersey. So you have a situation where there's no localization, right? They're working in New Jersey, they're working in Missouri, they're working in other states that they fly to, they're working in other countries that they fly to. So there's no localization answer. So you'd move on to the next question. You'd say, okay, well, next, is there a base of operations? And the answer there for this team is yes. They have a hub airport that they are flying in and out of. So for the employee, it's the place where their workday begins and ends. It's always the same. And so in that situation, it's like, okay, for localization reasons, these are all Missouri employees, even though they all live in New Jersey. So that's an example where you can kind of see, working through the set of questions, it was clear that there was no one state where they were more than incidentally employed other than Missouri. So it's sort of that combination of nexus. They have to be performing services in the state for that state to assert jurisdiction over the agreements that they sign. So you start there and you sort of work your way down in asking these questions. And then I have another example if we want to go to the next slide. Okay, so we have a New York employee who's been working with a company for a number of years. And then that New York employee decides, you know what, this place is not for me. My parents moved to Florida. I want to move to Florida. So they went from working full-time in New York, to working still full-time in Florida, but remotely. So now you have a telecommuting employee. The company agreed to let her telecommute. And once that movement happened, all of the assignments that this employee received were still coming from the New York office. So performing duties in Florida, the employer's located in New York, but again, like all of the employees' activities are happening in Florida. So that's a situation where you follow that baseline rule, right? Which is the location where the employee works from is the one that should be the governing law. So I thought we'd give you a couple of COVID-specific examples. We're almost out of time, so I'm just going to hit it really fast. We'll just do the first one. You have an employee that was in California. They moved to Colorado to work from home, maybe like be close to family. then spent 3 months in Washington because their partner got sent on a job to Washington, and then came back to Colorado. Who's in charge? Which law governs? And the answer is, for some employment law questions, it changes. So, they were a California employee, but then they moved to Colorado. So they were originally covered by California law. Now they're doing all their work in Colorado. Colorado law applies. Then they move for 3 months to Washington. That's long enough to form a nexus and to be working in Washington for a substantial portion of time. If it had been a couple of days vacation, there'd be an argument there, but it's 3 months, it's significant. And so if something happens during the time that they're in Colorado, it's very clear that they're a Colorado employee, they've relocated there. But what about that time they're in Washington? And that's where it can get trickier. But by and large, a lot of situations would say, Washington law would apply to them for incidents that occurred while they were in Washington. And so then the question is, what if there's a non-compete? What if there's, what should we have them sign? So when you're entering into agreements with your employees, the best rule of thumb is to have them sign something that refers to governing law in the state from which they are supposed to be working, and also have in place a telecommuting or hybrid working policy where you say, like, you are not allowed to go to X states, or even better, like, you must get permission from us before going to any other state and teleworking from there, and we'll decide at that point. That gives you the ability, if you need to execute a new agreement before they can go work from a new state, it gives you the opportunity to do that. So that's the best practical approach, is have a policy in place that doesn't let them move somewhere or relocate somewhere without first getting permission. And at that stage, as a company, you can determine whether you need a new non-compete, non-solicit, or other agreement to be put in place. We are right up against time. Adam and Josh, I don't know if any questions came in the chat that you want to address really quickly before we close out today.
We had a lot of questions. I think we got most of them answered. I think we got all of them answered, so there don't appear to be any outstanding right now.
Okay, I will say, I did see one that I'll just reiterate, the work from home situation. If you want somebody to sign a new employment contract, in most states, that change in circumstance would be significant enough that you could get a new contract signed. And especially if, some of the policies that are going to apply to them are going to change. There's going to be, different benefits and different drawbacks to working from home. So consideration is changing. If you're in a state that requires new consideration, the ability to work from home could be that. So thank you so much for joining us. We're very happy to have assisted anyone today who had questions. If you have more questions, you can reach out to us. You can also learn more about the solutions we do provide on the employment agreement space at 650.com/agreements. And we hope to see all of you again at the next webinar.